Good evening and welcome to the August 24 work session of the Harbor Coastal Commission. I'm Chair Thomas Burt. We are typically broadcast live on LMC TV, and due to technical difficulties, we will not be able to broadcast live this evening, but the video of this meeting will be made available to the public as soon as practicable afterwards. We are in the village courtroom, and it is open to members of the public who wish to view the work session. We have a short work session agenda tonight, and the first and only applicant item up tonight is a marine structure permit for Foreshore Road. At work sessions, we don't deliberate on applicant issues or the applications. We talk about completeness, and the applicants are welcome to view that and take what guidance they may from the issues that the documentation we intend to ask for, or the issues that we expect we may discuss. I'm going to ask Andrew Maggio to address Foreshore Road.
Thank you. So I've reviewed the relevant documents that are on the Novus site. It appears Race Consulting is doing the engineering. There's reference to underwater land. That's something the applicant should be prepared to discuss and show their ownership. Much like other applications in that area for the same use, we want to schedule a site visit, and that's something else that we always find useful and that we'll want to do. I happen to be in the area. I went by the property today. It's an active construction site, but I'm sure we can get some cooperation from the applicant on all of us actually attending there. The harbor master should also weigh in on this. That this is a corner of the Mamaroneck Harbor there. That there's some water issues. There's the Van Amridge Mill Pond Dam there. So the harbor master may have an opinion on this application, and we'd like to hear from him. I also noticed that the piles are timber or wood, rather than some of the other applications we've seen where they're metal. So and we've got an issue with the DEC about stops and docks resting on the seabed. So the applicant should address those issues. Also, we would like an environmental impact report from Sven. For informational purposes only, it'd be edifying to know what kind of vessel, what type of vessel will be used and docked at this marine structure. And also water depth has been an issue in that area as well. So some soundings of that area have been helpful on past applications.
Thank you. I also want to note that some commissioners, including at least myself, have addressed the breadth of our view shed concern. Obviously, the view shed expressly includes anything that can be seen from Harbor Island Park. It remains my view that its express inclusion is not a limitation, and that view shed also includes things that our residents would expect to be part of the visual world of our coastal village, and that therefore marine structures have view shed concerns in the outer harbor. So I know Race Coastal has been on prior applications where that's been addressed. I would expect them to come prepared to talk about whether this structure is in keeping with the visual presentation in scale and general appearance, visual presentation that our neighbors expect us to safeguard as part of our village. Does anyone have anything else that they think the applicant should come ready to address on the foreshore marine structure?
The only thing I had is there's a couple of really typo-like items that the AKRF memo to the planning board lined out that I actually noticed as I was reading through before I saw that it was summarized, that I think for good order should be cleaned up for our application as well.
Thank you. Okay, I think we're through the foreshore issue, and that concludes our applicant agenda. We have some administrative items, the first of which is there's currently some work going on Boston Post Road Bridge at Harbor Island Park. We had received correspondence in 2019 from or we had sent correspondence back and forth with the state in 2019 and again in 2020 concerning this project. We were asked several months ago if the commission saw any issues with our LWRP policies around this bridge, and at the time we had only a general description of the project, and all we knew is that they had finally hired a design firm and intended to move forward. So we sent correspondence back saying that essentially this is not the record that we usually do consistency on. We don't see any problems, but that we expected to see them back on a full review. Sometimes we're wrong-footed by a loss of institutional memory here, and I think we had expected the state to come back with a complete set of plans so that we could review it as expeditiously as possible, and that did not happen. So we did some review of the process, and together with our counsel, we came to an understanding about how this works. When the state comes to us for consistency, if we don't outline any policies that we think create an issue with the project, they take that as an indication that they don't need to come back. If we do outline a consistency issue with a state project, they then have a process, and it's not a super well-defined process, but they then have a process of consulting with us to resolve it, where we don't sit completely on our own in our normal review capacity, but instead work with the state and the applicant to resolve our concerns. When we see state projects in the future where we sit on consistency, we need to adopt a process where if we think that the project could touch on one of our policies in a way that would cause us to find it inconsistent, we have to flag that so that as the project gets defined, we either can see that there are not issues with that policy, or we are part of the discussion on how they get resolved. Because if we simply say we don't see any showstoppers now, but we'd like to re-review it, we will not get that opportunity. And that's a power that the state has. So it's a matter of our process. When these things come before us in the future, we have to outline carefully, anticipatorily problems that could arise so that we remain part of the conversation. We have also recently seen it, by recently, I mean in the last 3 years, seen applications that are from the municipality or the county. And recently what we've seen from the village or the county have mostly been marine structures. Marine structures are somewhat different. We are advised that on a marine structure where we are the permitting authority, the process is more like local zoning. In which case there is a doctrine called, TJ, remind me if I get this wrong. There's a Monroe balancing. Is that right?
Yeah, for county municipal projects, from one municipality wants to do a project in another municipality, it's a Monroe balancing test. That's correct.
Okay, so there's state guidance about how to apply a Monroe balancing test, but when the state or county comes before us for a marine structure, the applicable guidance is the state's Monroe balancing. So the next time we see an application like that, we will make sure that we internally distribute that so all the commissioners understand the limits of our powers, and then we'll use that as as guidance to address municipalities. It is not the case that a municipality or a county is exempt from everything that we do. We sit in two capacities here, both for consistency on our LWRP policies and also as the permitting authority on marine structures. Those have possibly somewhat different implications for states and counties. But when we sit as a marine structure permitting authority on village projects or on county projects that go in the harbor, we have a somewhat a set of powers that is somewhat limited by Monroe balancing, but we still consider them. So the applicant should be prepared to do that, and we should be prepared to make sure that they understand what the limits of those applications are. Unless, does anyone have anything on that? Okay, our next administrative item, I think I'm taking these a little bit out of order, is the Wetlands Law. We had voted several meetings ago a Wetlands Law as a recommendation to the Board of Trustees. For various reasons, I think it has never been taken up by the board. And I had occasion to, there was some confusion about the state of the draft, and I had occasion to look at it. And I think my recollection is that the last thing we did was make sure that we had included a buffer definition, but the version that I think is floating around as the operative version, either it didn't get added, either it's the wrong version or it didn't get added. We, I think, need to add that in several appropriate places, and probably in order to make sure that the Board of Trustees timely considers it, we probably need to circulate that and show up ready to make sure that it's what we thought we voted on at the next meeting, if we are at all able. I will take the laboring oar on that. I'm sorry I haven't gotten that out yet. Comments from anybody on the wetland law? I understand that we have some correspondence about plantings from Stuart Pickert. Since he is often in attendance, if he can be, I am going to suggest that we not take those up until we have a live session. We can always do that as an administrative item at our next meeting. And I think that leads us to our last item, which is there has been an Article 78 petition, and we should talk to our counsel, since that is current pending litigation that falls within the standards for an executive session exemption of open meeting law. Unless somebody wants to take up another item before we go in executive session. Anybody? Okay. I'm going to move that we enter executive session to discuss a currently pending litigation. Do I have a second?
Second.
All in favor?
Aye.
Okay, we're going to terminate the recording, as the remainder of this discussion will not be part of the public record. Thank you. And I do want to say that for all those folks who have been affected by the flooding from Hurricane Henri, I hope the property damage is minimal and you get past this as quickly as possible.
Okay.